Okay, today is May 6, 2013. This is Children in Justice. It is the last class, although we will meet next week during exam week, and you will take the examination in class. As I mentioned a moment ago, much of what's on the final exam I reviewed during last week's lecture, and I will review during this week's lecture. One of the things that I forgot about that I want to emphasize to you, by the way, is about forensic interviewing. This was a few learning modules ago when we talked about forensic interviewing and how an investigative interview might go. Now we know that the big bugaboo is, the big problem with interviewing potentially is when investigative interviewers ask leading or suggestive questions. Now I want you to understand that leading or suggestive questions are not always bad. There are some contexts in which, or sometimes when an investigative interviewer, a forensic interviewer, a child interviewer can ask leading or suggestive questions. Sometimes kids need a little cue or prompt. That's why I taught you about recall memory and recognition memory. Sometimes recognition memory can be tapped into, not by a pair of sunglasses or the smell of some cut blades of grass or a picture, but by a question itself. We talked about recognition memory being triggered by a visit to the crime scene. You know, the sights, the smells, being in that place where the crime took place might jog a participant's memory. Similarly, a question can be the trigger, the cue, the prompt to tap into kids' recognition memory. And the younger the child, the more difficult it is for them to provide a free recall narrative. Remember what free recall is. That's that amount of memory that we produce without the aid of cues or prompts. Right? But little kids aren't good at that. Or sometimes kids are very emotional about what they're about to talk about. They don't want to say negative things about dad, or they don't want to relive the molest, or they feel ashamed or embarrassed or responsible for what they're about to tell the interviewer. So they may be avoidant. Avoidance simply means when they're being interviewed, they may not want to talk about it for a variety of reasons, some of which I just outlined: shame, embarrassment, don't want to get daddy in trouble, and the like. In those cases, a suggestive or leading question or two, just to get the child just to get the child on track, might be advisable. What you don't want to ever ask is a misleading question. You see? A leading question is a question that gives information to the child, or any witness for that matter. What you don't want to do, and those are to be avoided, but I just got done saying sometimes they're necessary. Okay? Not a lot, once in a while, to jog that child's memory or get them talking about something that they are avoidant about. Okay? But a leading question is one that has information in it that's true. A misleading question is a question that has information that a child has never offered or is wrong. You know, when daddy put his finger on your butt, did he rub it up and down or did he kiss it? Now, the child never said anything about daddy touching their butt. The child never said anything about kissing. The child never said anything about that. That is not a leading question. That's a misleading question. So I just want to clarify there, at the same time emphasize that sometimes it's okay to ask, once in a while, a mildly leading or suggestive question. Does that make sense? Mm-hmm. All right. We chatted about excited utterances a few times. That's an exception to the hearsay rule, right? And we talked about when somebody says something in a nervous, agitated, excited way, without a lot of time for reflection, right? That might be an exception to the hearsay rule. And one of the reasons I like child protection workers and detectives to understand that is because if you document better, we, the DAG and the prosecutor, might be able to get those kinds of excited utterances admissible in court. Okay? But excited utterances are usually utterances that are made at or near the time of the event. You saw daddy burning your brother with a cigarette, and the child screamed out, oh my God, and made some kind of statement. Daddy's burning Billy, or something like that. Well, that's made at or about the time it's happening. It could be an excited utterance or even what we call a present sense impression, which you're not responsible for. But bear in mind that a day or two after the event is probably too late in most cases, and there's certainly no rule that requires that it happen a day or two after the event. The statement is usually at or about the time of the startling event, and that allows it to be testified to in court, okay, even though it is technically hearsay. Now, last week we wrapped up with our discussion of confidentiality and the issues surrounding confidentiality. I want to revisit that a little bit before we move on to the last section of your studies this semester, and that is expert testimony. But we talked about a couple of sources, actually 3 sources for confidentiality. We went over that last week and the week before. Sometimes you can pierce confidentiality. Sometimes confidentiality is overridden. Give me an example, class, someone in class, of a situation where, although the information is confidential, it is overridden by some other important policy reason.
When you're going to harm yourself for someone else?
Say that?
When you're going to harm yourself for someone else?
Well, when you're going to harm yourself for someone else. And that came from what case? There's a lot of rules. Tarasov, thank you. Tarasov versus the Board of Regents of the University of California. You don't necessarily have to remember all that fancy name. Just remember Tarasov. And Tarasov was about the duty to warn, and that's what you were talking about. Sometimes it's a duty to warn, and it's more about third parties, not yourself. It's more about you're going to harm a third party. But there were some requirements that developed throughout the years when it came to Tarasov. What kind of threat must it be? A serious threat. Good. What else? Imminent risk of what kind of harm? Grave, serious, big-time harm, right? To who? An identifiable third party, right? So remember, it's the duty to warn. If it's not an identifiable third party, who are you going to warn? Whose parents are you going to call? So you need to have an identifiable third party, right? Those are the duty to warn cases. Did I miss anything? A credible threat. Thank you, Susanna. A credible threat. And psychiatrists, psychologists, and mental health professionals are usually in a decent position to size up whether a threat is credible or not. Very good. So that would be an example of confidentiality being, overridden by some other public policy consideration. Now, you're a child protection professional, and you're in your office, and you get some paper in the mail, and you open it up, and you can see that the letterhead is from a law firm, and the first line says, "Greetings, you are hereby commanded to appear at the Passaic County Civil Court, 135 Grand Street, Patterson, New Jersey, on the 5th day of November in the year of our Lord," with Old English font, thick bond paper, and it's got a notary stamp on it, maybe a drop of red wax. Nah, not really, but pretty fancy document. What am I talking about? A subpoena. Can a validly entered or issued subpoena override confidentiality? No. Validly issued subpoena?
No.
Yes, it can. A validly issued subpoena can override confidentiality.
You have to answer it, but...
You have to respond to it. You should seek counsel. And whether or not the subpoena overrides confidentiality depends upon who's asking and what they're asking for, right? Who's asking and what they're asking for. If the subpoena is asking for information about mandatory reporting or a credible threat of serious imminent harm to a third party, that subpoena may override confidentiality. And perhaps it's a misnomer. The subpoena in and of itself doesn't override it, but if it's validly issued and it asks for information that overrides it, the subpoena can trigger piercing confidentiality. So a validly issued subpoena is something that could override confidentiality. Depends on what they're asking for. Now, like I told you, many lawyers have a book of these. You can go online right now and search Google and find a million subpoenas and subpoena forms. So be careful, always go to an institutional attorney to talk about that or follow the policies. The other thing that might override confidentiality is something we really didn't talk about much, but I'm going to emphasize it right now, and that is the constitutional rights of the defendant. Remember that we said that the defendant has a number of rights. All people have rights that are embodied in the United States Constitution. The Fourth Amendment allows us to have a certain degree of privacy in our things, in our places, on our bodies, right? The government can't go in our pockets or our purses or our cars or our homes or our drawers, okay? Dresser drawers, that is, without having probable cause and an exception to the warrant requirement. Otherwise, they need a warrant. There are many exceptions to the warrant requirement, but if you go through somebody's purse on the roadside without a warrant, on Route 80 at 3 o'clock in the morning, you better be able to articulate or explain why this was an emergency situation and you didn't have a warrant. So the Fourth Amendment is one amendment that protects the accused and everybody. And we all are potentially accused one day. Hopefully we make it through life without ever being accused. The Fifth Amendment gives us a privilege against self-incrimination, that if the government hauls us in for questioning, we don't have to answer their questions. Ever. The Sixth Amendment is a couple of real important ones that were very important throughout the semester, and you might want to pay attention to them for the exam. The Sixth Amendment right to counsel, and remember that came up with juvenile justice, and the kids didn't have a right to counsel, and then came Winship and Galt and those cases, and then the kids did have a right to counsel. But perhaps the most important one for child protection and children in justice was the Sixth Amendment right to do what? Of the witnesses against you. Cross-examine and confront the witnesses against you. That came up big time in JQ, JG, right? Those cases we read, KAW. KAW was about children and dates. The defendant said, hey man, the kid came in and can't tell us exactly when the crime happened. If I don't know exactly when the crime happened, how am I going to be able to question the kid? If I can't question the kid about the day that this happened, my right to confront the child is being impaired or undermined. And it's being violated, my Sixth Amendment right to cross-examination. Hearsay is all about the Sixth Amendment right to cross-examination. If Officer Bill Mott comes to court to testify about what Gabriella said, and then Gabriella told me her father comes in her room at night and puts his hand on her pants and touches her on her vagina. We don't want to hear that from Officer Bill Mott. That's hearsay, unless there's an exception. Maybe Gabriella was all excited and nervous and made an excited utterance. Maybe Gabriella thought Bill Mott was a doctor. Remember, things you say to your doctor for purposes of diagnosis or treatment may be admissible. But if Bill Mott's testifying and Gabriella's not in court, that involves the Sixth Amendment of the Constitution right to confront the witnesses in court, right? I don't want to hear from Bill Mott. I want to confront Gabriella. Hey, Bill Mott, don't tell me what Gabriella told you. Prosecutor, what do you got Bill Mott in here for? Bring in Gabriella. You're violating my right to confront the witnesses against me, okay? That's a Sixth Amendment issue. Now, imagine there's a pile of DIFAS records, DCP&P records, child protection records. They're confidential. I don't get DIFAS records. When I started my career in child protection, we do joint investigations. If a referral comes in and it's an institutional case or it involves an emergent case where a caregiver may have abused a child sexually or physically, but mostly sexual, if it comes in like that, we're working a job together. Right? You're coming down, you call the detective, we're meeting here, we're bringing people there, we're going over there, we're working together. Certainly, DCP&P will write their report. Right? You'll enter your notes in the NJ Spirit or whatever you do, you'll enter those notes, and our detective will write a report as well. I don't need your notes, because every place you were, my people were. Now, maybe we weren't there, maybe you went and picked up the mother or something, that's not that critical. I don't need your report on whether the mother was wearing shorts or long pants or, you know, if we ever come to that, maybe I'll get your records. The point is, I don't get your records, so I say I. The Passaic County Prosecutor's Office Special Victims Unit doesn't get your records Because I don't want to get those confidential records and then open them up to the defense wanting to look at them. Okay? If I got them, the defendant goes, Del Russo's got the records, I want to see them. Why do you want to see them? I want to check them out. Maybe there's something that helps my guy out. Maybe there's something in there that helps my client out. Judge may say, what about that, Del Russo? I say, Judge, they're confidential. Well, you got them. Yeah, but I'm not going to use him against them. Then why do you have them? Well, I just want to see if there's something in there I could use against him. Judge says, well, what about him? Doesn't he have a right to look? And you know what? In the end of the day, I'll probably win because they are confidential, and unless there's something material to the defense of that accused, he ain't getting them. But by having them in my physical possession, it changes the whole dynamic of things, believe me. So I don't get them. You'll keep them. And if they ask me for them, I tell them where to send their subpoena. I think it's 157 Halsey Street, Newark. I'll be there tomorrow. 153 Halsey Street, Newark. Thank you very much.
I'll be in training.
There you go. Well, I won't be there. I'll be in Gateway, whatever, 3, 2, 1 or something. In any event, the Sixth Amendment rights are important. And sometimes there may be information in those confidential records that Child Protection has that help the defendant exercise his constitutional right. I'll give you a very common example. Defense lawyer comes to me and goes, hey, Joe, your girl in that case, Gabriella, the mother told me that they were at the therapist's office the other day and she recanted it all. I'll be like, I didn't know that. Is that right? Yeah, how do you know? Because my guy told me. How does he know? Well, him and the mother are still talking, you know what I'm saying? I don't have the records. Where is that documented? The DIPUS records. So, now I got an issue. And without going through the procedural steps that would happen, those records are going to go to the judge. The judge is going to review them in camera. In camera is a fancy way of saying in his private or her private chambers. And then she will decide if there's anything relevant or not to share with the defendant. Because if that child recanted and it's in the DIPUS records, then that is something that would help the defendant exercise his Sixth Amendment right to do what? Cross-examine and confront the witnesses against him. He wants to be able to cross-examine Gabriella when she takes the stand about what she said at the therapist's office. By then, she may have flip-flopped 3 times. And that's all good for the defense and not so good for the government. Nevertheless, I told you last week, you know, the recantation cases are among the easier ones, actually, in the end. But there, the Sixth Amendment rights of the defendant override confidentiality. You understand what I'm saying? I asked you, what can override confidentiality, right? One reason might be a duty to report, right? Mandatory reporting could override confidentiality, right? Duty to warn a third party might override confidentiality, right? The defendant's constitutional rights might override confidentiality. I just gave you an example of that, right? I talked about a waiver last week. I talked about some education lawyers or hospital lawyers not wanting to give me their records because of HIPAA. And I say, listen, sir, I have a waiver. The person whose records they are, the patient whose records that I want, the hospital records, the private hospital records I want, the person whose privacy is an issue, wrote it on a piece of paper, I want my records. Please give them to the government. I'm going to give you a waiver. I don't say it that annoyingly and obnoxiously, but I say, listen, I got a signed waiver from the patient. No, not good enough. Not good enough. It's a waiver. I'm not giving it to you. Okay? This is risk, what do they call it? Risk management. We're not giving it to you. Risk management rule number 42B. Okay, but if you get us a subpoena, then we'll give it to you. Oh, okay, I'll go get the subpoena papers out. Give him a subpoena. The point is, that person's wrong. A waiver, client consent, can override confidentiality, right? You got a right to your medical, even HIPAA allows you to get your own medical. Sorry, you can't get your own medical records. What? We're protecting you from who? Me? That's my records. A valid consent or waiver can override confidentiality. Does that kind of make sense? All right. Now, we watched a video clip of a pharmacist who seemed to do everything wrong when the cops came to ask questions about diazepam or whatever, some drug that a person in a homicide or not a near homicide was taking. I called it confidentiality ignored. Remember we watched that video clip? Well, in that case, the pharmacist, let's assume that she ignored confidentiality and broke the rules. What could be some of the punishments she might receive? What could happen to her? She might be fired, right? But pharmacists are licensed in this state. Okay. She could lose her license, which is the most drastic outcome. What else could they do to her, short of losing her license? Suspend her, exactly, you're on the right track. Suspend her. The International Association of Pharmacological whatever, the Pharmacy Association could kick her out. But she could be suspended or have her license revoked. Those are the biggies. Certainly she could be kicked out of any pharmaceutical associations that she's part of. And what about the woman who's lying in a coma? Maybe she regains her consciousness and lives a happy, healthy life. What might she do? Sue. And the pharmacy, take my word, one of the defendants, probably the first defendant, in bold-faced caps, will be Dwayne Reed, and then the pharmacist. Okay, because Dwayne Reed's a multi-million-dollar corporation, and of course the pharmacist probably doesn't have that kind of money. Civil lawsuit. Very good. Now, we're going to start talking about expert witnesses and witnesses in general and how witnesses are handled in the courtrooms. Before I do that, since I was talking about Daniel earlier, one of the ways that witnesses are challenged in court is through cross-examination. In cross-examination, I'll talk in a little bit more detail about in a few minutes, because I want us all to be prepared if we have to testify in court. Now, this couple of hours we spent talking about this today is not going to fully prepare you, but it'll give you some insight into the rationale behind cross-examination, a little bit about how to prepare for it and how to think about it, so it isn't so disconcerting for you as a witness when you're in court. I asked a prior class here at Montclair State, what they thought about it, and some students just raised their hand and said, it was the worst experience of my life. And, she certainly didn't have a positive experience, and she told us why, and, the lawyer was mean, and the AG didn't seem to be in her corner or protecting her, and she was sick that day. She really wasn't in the best mood or spirits to be a witness, and, all of that can be remedied for the most part with preparation. The AG and her should have been prepared, talked about the issues in the case. If she wasn't well, she should have testified. There's a number of ways to get around that and not have such a negative and somewhat ugly experience. But before we do that, cross-examination is about asking questions in the courtroom designed to impeach the credibility of the witness, to either show that they're not being truthful or that they're misinformed or that their recollection isn't as good as they thought, that is, the witness thought. You want to show that the witness's testimony is not persuasive for some reason. And then sometimes cross-examination is about making a point. If the point is that you usually call the prosecutor's office when you get these kinds of cases and you didn't do it this time, and you say, no, we don't usually do that, then the lawyer might ask you a bunch of questions designed to show that you do usually do that, and that you are misleading us when you say that that's not protocol. So sometimes the defense just wants to make a point and the witness isn't agreeing. And if the witness isn't agreeing, the defense lawyer has to ask questions to get to that point. And in the end, you might say, well, yeah, that's true. we do usually call the prosecutor's office. I didn't do it in this case, that was my mistake. I mean, if that's what should have happened, in the end, we should always fall on our sword and be contrite and just accept responsibility when we make mistakes. Juries like that. They like when we accept responsibility when we make mistakes. Anyway, we were talking about Daniel before. This is an example of Daniel cross-examining me when he's 8 years old, because he's got this notion in his head. Okay, he's not trying to show me to be unbelievable or my recollection is frail for some reason. He's just trying to make a point that he disagrees with me about. And he's going to ask me a series of questions where he thinks he's going to back me into a corner and prove his point. Well, actually does kind of a good job if you think about it. But here's what he says to me. He says, if you go to jail, because he listens to me talk on the phone, we talk about my job once in a blue moon. He says to me, if you go to jail and you make friends while you're in jail, could you stay in jail after your sentence is over because you want to hang out with your new friends? I go, what? Stop asking me silly questions. No, I just want to know, could you... What? Come on, man, what are you talking about? Could you stay in jail if you made friends? You want to stay in jail? And I am dismissive of it, but who wants to do that? I just want to know. No, you can't. Why not? Well, you'll see. Listen to him. I try to annotate it or put subtitles, so I think we should be able to see the subtitles. What happened? Oh, stay in jail, yeah.
And if you meet a friend in jail, whether you can...
Okay, wait a minute. How do I get this to play with, open with here? QuickTime Player. All right, now we're rocking.
So you're asking me, if you meet a friend in jail, whether you can ask the jail to stay longer because you don't want to leave?
Yeah.
Is there a reason that you would want to stay in jail?
Well, could you ask her?
No.
You're not allowed?
To ask to stay in jail for longer?
Yeah.
No.
I bet you wanted to.
I think you're missing the point, though. Jail is a nasty place.
No, it is.
But no, they won't do that. They won't let you stay in jail, even if you enjoy the nastiness.
Yeah.
No.
Fine.
By the way, he doesn't know he's being recorded. I did this with my BlackBerry. We're in a car. We're in a car on a Sunday. Of course, they won't know why.
Because jail is to put people in who commit crimes or offenses against...
Aha, you did commit a crime.
Yeah, but your time is done. You served your full sentence, and you're about to be released. You can only be kept as long as the rules say you can be kept in jail.
Why didn't you don't get out of the jail?
What do you mean you'll get out of the jail?
Why didn't you don't? If they say get out.
Oh, you mean you won't leave? Then they put you in... Then you get in trouble. If you won't leave, then they'll arrest you and put you in jail.
Yeah. Yay! And that's the way to do it. It just seems like 2 minutes longer.
Well, I think they might also maybe put you in the mental hospital too. But...
It just takes 2 minutes longer.
Yeah, well, he proved his point through a series of questions. He made an assertion, and he was able to demonstrate that, yes, there's a way to stay in jail and hang out with your newfound friends if you really want to.
How did he respond to the mental institution part?
Well, I might have just went right over his head. I think by then he was so happy with his success that he didn't care about the potential institutionalization. In any event, that leads us into Chapter 7, where we talk about witnesses and the questioning of witnesses and the different kinds of witnesses. Chapter 7 is called Expert Testimony, and I want you to realize that there are generally 2 kinds of witnesses in the courts, whether it's civil, criminal, family, matrimonial. Lay witnesses and expert witnesses. Lay witnesses, L-A-Y, are the witnesses who have personal information about the issues in the case. They're the witnesses. They're the person who saw something, heard something, smelled something, experienced something. They are our traditional witnesses, right? They have relevant information about a fact or issue in dispute in the case. An expert witness is someone with special knowledge who helps the jury understand technical issues, maybe psychological or clinical issues, maybe scientific issues. Sometimes the expert doesn't know anything about the case. Sometimes it's a good idea for the expert not to know anything about the case. But an expert witness is someone who helps the jury understand an issue that is beyond the comprehension or understanding of the average person. Okay? My law school professor used to tell me the story of little Billy. Billy collected butterflies. Billy was 12 years old, and he's been collecting butterflies in Wayne, New Jersey, which is in Passaic County, about 7 miles from here. He's been living in Wayne and collecting butterflies in that area between ages 7 through 12. He's taken out 15 or 20 books about butterflies from the Wayne Public Library and his school library over the years. He likes butterflies, and he collects them, he catches them, he talks about them. Billy knows a little bit more than the average person about the presence of a particular butterfly species in northern New Jersey than anybody else. Certainly more than I do or you do. And that's all you need, is a little bit more knowledge than the average person. Now, if we brought in some expert in butterflies from Stanford University, okay, they may have more knowledge than the average person, and they too may be an expert witness in court. So whether Billy or the Stanford professor get to testify is the same. Both are going to get to testify because they both know a little bit more than the average person. And we're going to assume that whether a butterfly was in northern New Jersey at the time of the murder is relevant to the case. Now, how persuasive they are, the weight that the jury or the judge might give to their testimony might be different. Some might think that the Stanford professor deserves more respect than little Billy. On the other hand, Stanford's in California, Billy's in Wayne. I don't know. But anyone could be an expert witness. You simply need to know a little bit more than the average person. Now, some of the ways that expert testimony are relevant to children's justice, I'll start right off the bat with the most common one, the one where even a DIPUS worker, even a DIPUS worker with 5 years on the job can be an expert witness. And that is the Child Sexual Abuse Accommodation Syndrome. And while the average DIPUS worker doesn't have to know that syndrome inside and out or understand Dr. Roland Summit's article inside and out, although it would be helpful, if the issue simply was whether kids sometimes recant their allegations because of pressure from the non-offending caregiver, like the mother pressures the child to take back the allegations so that dad gets out of jail and can pay the bills and take care of the family again. Well, you show me an intake worker who's been on the job for 5 or 6 years, I'll show you an expert witness on whether kids sometimes recant and whether they're motivated by their mom to recant, right? I mean, that comes from experience. Just like little Billy collects butterflies, you know, the average DIPUS worker sadly has collected quite a few recantations in her career by her 5th or 6th year. So a DIPUS worker, a psychologist, a psychiatrist, a rape crisis counselor, a community mental health therapist, could be an expert witness about how children typically respond to intrafamilial sexual abuse. Okay? The common reactions of the sexually abused child was the subject of an article by Dr. Roland Summit, and it was called The Child Sexual Abuse Accommodation Syndrome. And in that article, Summit talks about the different categories in the syndrome that he observed many years ago, 1983 as a matter of fact. And the syndrome says there are 2 preconditions: secrecy and helplessness. Children who are molested within the family by a caregiver cannot be molested unless you have the two preconditions of secrecy and helplessness. Okay? If there's no secrecy, or if the children are powerful and can defend themselves, there will be no molest. These things only happen because families give the molester cover. It protects them from outside viewing. So you need secrecy, and hey man, that's the way families operate, right? They're families. Things happen in the home, shielded from public view. And helplessness is the state of childhood. It's just a fact of childhood. Children, by definition, are subordinate to their caregivers. They are in every way, shape, and form helpless, powerless. They are completely subordinate to their parents, to their caregivers, who tell them what time to get up, what time to go to bed, whether they can wear particular sneakers or not, whether they can save money to pay for those sneakers, whether they can go out on a play date, whether we're going to call it a play date, whatever goes on in that child's life is defined by the caregiver. And they are powerless to do anything beyond that. So secrecy and helplessness create an environment where abuse can take place. Those were the first categories of Summit's articles: secrecy and helplessness. And because the children are helpless, they are entrapped. That's the E. Secrecy, helplessness, E. We call it SHE-Doctor to help remember it, the acronym. Secrecy, helplessness, and entrapment. In fact, he calls it entrapment and accommodation. And what he means is, because these things happen in families, because families are private entities, because children by definition are subordinate and helpless, when they are molested over and over again by a caregiver, they accommodate. There's no way out, there's nowhere to go, you can't tell anybody. The guy who you would tell, or the gal who you would tell, your mother, your father, are the problem. They're the ones molesting you. The very people that you would turn to, the very people that you would turn to for help are the ones who are taking advantage of you. So you're trapped. That's entrapment. Accommodation is, well, you can't get out. This is going to happen. There's no way for me to defend myself. Let me figure out ways to help me cope. Let me figure out ways so it don't hurt so bad. Let me figure out ways so it doesn't happen as often. Kids will hammer nails in their door. They'll wear baggy clothes. They'll desexualize themselves. They'll stay late after school. They'll leave early for school. They'll always be hanging out with their siblings. They'll do everything in their power to make themselves unavailable, diminish their sexuality, and protect themselves. And if they all fail, they resort to psychological coping mechanisms. Okay, suppressing it, not thinking about it, and the worst aspect of that, dissociation, where they leave their body and they get molested, and then they return to their body, metaphorically, when the molest is over. That's a psychological concept that we call dissociation. And these are some of the many ways that kids figure out how to go on living knowing that they're trapped and they're going to get fondled and touched and molested until whenever. And usually that whenever is in adolescence. But in any event, secrecy, helplessness, entrapment, and accommodation, right? Entrapment and accommodation. Delayed, unconvincing disclosure. That's the next step. Eventually it comes out, usually when they hit adolescence, usually when they have a little power. Their world is expanded a little bit. They may be in high school, they may have a boyfriend, they may have a special teacher they look up to, a different adult who's a good role model, someone that they trust, and it comes out. Sometimes a little bit at a time, sometimes a whole lot of it, but it almost always is delayed. Very few incest victims tell the day after the first molest, for a variety of reasons. It's their father, it's ambiguous, they don't understand human sexuality, they don't even know what to say if they knew how to say it, they don't want to get the person in trouble, they're scared of the consequences, they don't think they'll be believed. Very, 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 very few kids tell about incest the first time it happens, for all of those reasons I just ticked off and many others. And when they do tell, for some of the reasons I suggested a moment ago, it comes out in a jagged, non-believable, herky-jerky way where they're testing the water, seeing it till we believe, you know, that kind of stuff. It's delayed and unconvincing. And the reason it's unconvincing is because they don't come out and say, sit down, Mom. Let me tell you the sad story of what Dad's been doing to me. The first day was in April 2006 when you were working late at the hospital, and that's when you got the award for nursing. Remember that day Dad came in his room with his left hand? He goes, Dad, no. Doesn't come out that way. Sometimes it comes out like this. I'm not going to the softball banquet dinner with Dad. No way, shape, or form. He's not giving me the award in front of my friends. What do you mean? You're disrespecting your father. He doesn't deserve my respect. How can you say that about your father? He's been coaching you in softball since you're a little kid. He loves you. He doesn't love me. You think he's so great? He's been fucking me since I'm a little kid. What? How could you say that? How could you say that about your father? You go to your room. You suck. In the middle of conflict, strife, anger, adolescent rebelliousness, in the nastiest ways imaginable, these disclosures sometimes come out. Sometimes they come out a little bit different. Sometimes they come out and say, I don't want to go to the banquet with him because he's creepy. I don't like him. Why? Why did you say that? I'm not telling you. I'm not bringing it up. 6 months later, they give a little bit more. Maybe a month later, they give a little bit more. Then they finally let it out of the bag. Well, that's not a very convincing way, right? The grown-ups who hear how it came out aren't going to embrace that kid, right? They're not going to embrace the kid who makes that disclosure in the middle of familial conflict, as sometimes, many times happens. They're not going to embrace the kid who gives it out in little dribs and drabs. So Summit says the next step is delayed and unconvincing disclosure. And then sadly, and you know, the data rates vary. We used to say in about 1 in 5, maybe 1 in 10 cases, kids take it all back. They recant. And that Summit describes as retraction or recantation. That's the last element of the child sexual abuse accommodation syndrome. They recant and they take it back. Now, the good news is for deputies, attorney general, and for prosecutors is when kids recant or when kids make clunky, awkward, piecemeal, unconvincing disclosures, we can bring in an expert witness to tell the jury or the judge how the typical kid responds to incest or intrafamilial abuse. Basically, what I told you, we get to tell the jury. Not so colorfully, not so loudly, but we get to tell the jury through the use of an expert witness. But here's what's critical to remember, and pass this along to your friends who stepped out of the room. What's critical to remember is that this is not a diagnosis. The child sexual abuse accommodation syndrome is based on clinical observations of the typical reaction of abused kids. You can't line up what the abused kid did. Okay, they told in a fragmented way, it happened in a conflict. They said it happened when they were younger, and then they took it back. Aha, they must have been abused. It's not a diagnosis. You don't diagnose sexual abuse like a sore throat. Okay? Or not even a sore throat, like, what's that when you get a culture taken? Strep throat. Okay? This is just information to help the jury understand how kids may act if they're a victim of incest. It's another way that the playing field is leveled for the children. If there's any theme, any overriding theme with how I present this children in justice class, it is one of a history of leveling the playing field for the kids in the justice system. We have a justice system, and I like to emphasize how New Jersey, to their credit, New Jersey, we're not always on the leading edge, but when we are, it's good. New Jersey, through its court system over the years, has leveled the playing field for the kids in a variety of ways. This is one other example of it, and that's kind of the theme that I've been emphasizing throughout the semester. Kids get a break when it comes to dates. Kids don't have to get examined a second time if they have a medical exam that's going to be used in the case. Okay? Kids don't have to get a psych eval simply because they're kids. RW. kids who are molested within the family have a right to have the jury understand that simply because they didn't tell right away doesn't mean it isn't true. That there are very valid reasons why kids might be molested and not tell right away. And sometimes put themselves in positions where they will be molested. Sometimes kids will still take a ride with dad or love dad. I've had defense lawyers want to bring in pictures of the child on dad's lap, hugging and kissing him at or about the time the molest was going on, to show to the jury that how could this kid be molested by this man and she still demonstrate all this affection. I've had lawyers bring in stacks of birthday cards and Valentine's Day cards. I love you more than anybody in the world, Dad. And want to give that to the jury and pass it around so that the jury disbelieves the child, so that the jury concludes that this child's lying about being sexually abused because she loves her dad, and at the time she was being abused, she sent birthday cards professing her and dying love for her father. Well, that really misses the point of childhood and families. And we got a right to tell the jury that. That levels the playing field. It's important for us to do that. The case was called State versus JQ. JQ. That's the New Jersey Supreme Court case that says we can introduce the child sexual abuse accommodation syndrome in the criminal and civil courts of the state of New Jersey. Not to prove abuse, but to help the jury understand that there's another reason why the kid might not tell right away. And simply because the child took it all back doesn't mean that they were lying the first time. Kids who were sexually abused sometimes take it all back for reasons that have nothing to do with the truthfulness of the original allegation. And we get to tell the jury that, and that's a good thing. And that's something that's important to children in our state. But bear in mind the distinction between the experts saying this kid was abused versus this is how kids generally respond to abuse. The latter, this is how kids generally respond to abuse, is okay. The former, this proves the kid was abused. This is a diagnosis of child abuse. It's not allowed. And it's not even true. It's not what child sexual abuse accommodation syndrome is. Can someone give me an example of how you might use an expert witness in a battered intimate partner case or a domestic violence, battered spouse, battered woman case? Give me an example. Go ahead.
So explain why the victim stayed with the batterer?
To explain why the victim stayed with who?
Batterer?
The batterer. The batterer. Why? Why does that need explaining? Sometimes what? Go ahead.
The jurors don't understand. They think that if you get beat, you can leave. They don't understand like the psychology behind it.
Jurors don't understand the psychology behind it because they think, hey, if you get beat, you're going to leave. And why would they need that explanation? What happens? I mean, it really begs the question. What is typical among battered women? They stay. They go back. So that makes the issue, and it is. Yeah, they go back. The research is clear. Probably an average of 8 times before they pack up, or they die, sadly. But about 8 times back and forth. Some less, some more. And, jurors don't get that out of the box. They don't understand that right away. Well, why, if she got her ass kicked so badly, why would she go back? Why would she do this? Why did she marry him? Why did she accept the engagement ring? Why did she go to the islands with him? Why? And we get to explain that. That's another way. We don't even have to talk about this case being the case that's being prosecuted. We just talk generally about how the average battered spouse or intimate partner might react. It may apply to this case, it may not apply to this case. Now, there are we call those lecture witnesses, where the expert witness comes in. There's kind of 2 types. The one kind of expert witness is a lecture witness who gives the jury information they may need without talking about the case that's being prosecuted. And the battered women case, they need information to understand how they typically respond. The child abuse case, they may need information about how they typically respond. That's the lecture witness. among the expert witnesses. Okay?
Can you repeat that, sir, please?
Yeah. You have expert witnesses. There's two types. One is the lecture dissertation witness, and the one is the witness, and I didn't get to this yet. The next one I'm going to tell you about is the expert who gives an opinion about this case, the case that's being considered, the case that's in the courtroom. So the lecture witness comes in and just testifies about how kids typically react to abuse. If the defense lawyer asks that witness, well, do you know what Gabriella said? They would say, who's Gabriella? Well, that's the victim in this case. Didn't you get the file? No, I don't review the file because I understand my role here is simply to educate the jury about how the kids typically react to child abuse. And if I were to read the file and tell these same jurors how kids typically react to sexual abuse, the jury might infer or think that I agree with the prosecution. So I don't read the file, I simply talk about, they wouldn't get that wordy, but that's the reason why. So that kind of witness gives, we call them lecture or dissertation, because it's like me, they're lecturing the jury. They're telling the jury about battered women syndrome. They're telling the jury about rape trauma. They're telling the jury about child sexual abuse dynamics. They don't know anything about the case. They simply give the jury information. Okay? They simply give the jury information. One time I had a case where a guy was accused of molesting his stepdaughter for many years. And it happened in the context of him helping her and her sister towel off after going to the beach. Now that is an ambiguous scenario. Remember we talked about leading questions and suggestive questions are more problematic? That memory is more frail or more subject to suggestive questions when you have an ambiguous context. Remember, bath time, diaper change, medicine application. That kids in that situation where it's ambiguous and can go either way, maybe the guy's doing it for the right reasons, maybe the guy's doing it for the wrong reasons. Kids are most vulnerable to suggestion, or are more vulnerable to suggestion in ambiguous scenarios. Well, this is not a common one, but he supposedly was in the shower helping them towel off to get the sand out of their cracks, as he said. In any event, so it could go either way. Maybe he was doing it for sexual reasons. Maybe he's just some goofball who's trying to help his stepkids get clean. They felt violated. So that's worth something. They were kids, but they felt violated. I'll get to you. They felt violated. Well, the mother tells me, oh, you know, I found a suitcase full of porn and dildos and Benoit balls and sex aids, and he's got girlfriends in Lower Manhattan. He reads the sex papers, and I go, listen, Mrs. X, I go, that's nice. I go, it suggests that he's sexually adventurous, has sexual perversions, but there's no correlation between, you know, infidelity and dildos and Benoit balls and all this stuff and child abuse or sexual abuse. You know, not enough to get it into court. We're not going to bring a suitcase full of sex toys to court that he found. She goes, oh, okay. She understood. And she said, well, you know, then the book that he gave Megan, you know, she said, I go, what book? So I'm kind of, she goes, oh, on her 13th birthday, he gave her a copy of Vladimir Nabokov's Lolita. I said, what? On her 13th birthday, he gave her a copy of Lolita? Yeah. I said, and you in child protection can appreciate this. You know, like, he wrote down that he was so sorry he molested my daughter, and he gave it to me at the dinner table. He wrote down that he was guilty on paper. Do you have the paper? Oh, no, I burned it immediately. What? I destroyed it. I burned it. I threw it out. So I said, do you have the book? Oh, yeah, I still have the book. Bring me the book. Not only did he give her the book, the first page said, on your 13th birthday, now this is her father, raised him since he's 2. On your 13th birthday, with love, Griff. His name is Griffin. Griffin Lytel. On your 13th birthday, Megan, with love, Griff. Griff. Now, some of you are going, what's he yelling and screaming about this book? Because you don't know what the book's about. Does everyone in this room know what Nabokov's Lolita is about? No, and you shouldn't. It's supposedly one of the great works of literature. I've never read it. I've read summaries of it. I knew what it was about. There were many movies. Many movies. The most famous of which is a movie with James Mason but there have been modern treatments of Lolita. It's about a middle-aged man and his sexual preoccupation. The movies make her 14. In Vladimir Nabokov's book, she's 12. He can't eat or drink or go to sleep without seeing that 12-year-old girl in his mind and thinking about raising her and having sexual sexual conduct with her, engaging in sexual conduct. So I got this book. What dad gives this to his daughter? What is this? Remember, ambiguous, right? Oh, I was simply toweling the girls off. Girls go, he's touching our body parts. He was molesting us. No, I wasn't. I was helping them towel dry. So I, as a prosecutor, I need to show that he was being a perv, not a dad, right? I have to somehow show that this wasn't towel drying. Because they'll buy that, the jury. They will. Because I got to prove it beyond a reasonable doubt. So I got to show somehow that he sexualized his own daughter. Thank you very much. The book. The book. He looked at Megan not as a daughter, but as a sexual object. That's what the book says to me. But the jury don't know what the book's about. I got 14 people in the box. I can't assume that they know what the book's about. So I called this university. I called William Patterson. I called Rutgers. I said, find me an English professor who teaches Nabokov's Lolita. And William Patterson had a guy. He goes, I used to teach it for a few years. I go, well, I'm going to ask you to be an expert witness in my case. I don't even want to tell you what it's about. But it's important that the jury be educated about the content of Lolita. And we don't pay. To his credit, he says, I would like to do that. That's cool, I would like to do that. So I have these. I could bring in the news clippings for you. I had long hearings. My adversary goes, who is Del Russo's expert to tell us what a book is about? A book can mean many things to many people. Books are allegories, they're metaphorical. Books can mean many things to many people. Who is he to tell the jury? It's the jury's function to determine what the book's about. I goes, Mr. Galluccio asking us to have the jury, all 14 of them, read a 1,400-page book for this trial? No, I'm saying this witness shouldn't be admitted at all. He should not be allowed to testify as an expert. Not at all, not one bit in this case. I go, Judge, look, Nabokov's book could be an allegory about the politics of Russia in the 12th century. It could be a metaphor for the crucifixion of Christ. But on at least one level, it's about a 52-year-old man who wants to have sex with a 12-year-old girl. That's what it is on its surface, and he's got a right to tell the jury what it's about. Judge wouldn't let it in. Wouldn't let the expert testify. I don't remember why, and the more I tell the story, the more convinced I am he was wrong. And I should have went to the appellate division, but he wound up pleading guilty eventually. The judge was my former boss and my dear friend. I'm still friendly with him. He's now since long retired. But I was a law clerk of his. When I got out of law school, I worked for this judge for a year. You know, and he's looked at me. My dad died at or about the time that I got the clerkship. He was like a father figure to me. And he's, I know what I'm doing here. I'm not allowing it. I'm not allowing it. I'm not allowing it. So we didn't allow it. Nevertheless, that's not relevant to what I'm talking about here. Had it been allowed, and I'm pretty sure if I went to the appellate division, it would have been allowed. Had it been allowed, the William Patterson teacher would come in as an expert lecture witness. He don't know nothing about Griffin Littell and Megan and the showering and the towel. We just tell what Lolita's about. Come in and get out. Why? Because the jury needs that information to understand his relationship with Megan. Now, I'm sorry, go ahead. You had the...
No, well, I was just wondering, because I saw this case like a very long time ago about a DV case. The only reason why I guess the cops believed that it was happening was because the lady's boss was documenting every time she saw her get hit or every time she called out of work kind of thing. So if we wanted to bring her in as a witness, would she still be as a lecturer or as an expert because she's the boss?
Well, she wouldn't be an expert at all, right? She'd be a fact witness.
So it's just a fact.
You're saying she made notes about the days that the victim was out of work or had bruises?
Yeah, but does it change if she's like, let's say somebody working in our field?
No, and that's a good question. Simply because you are an expert, don't make you an expert. DIFAS work, and that doesn't mean you couldn't be an expert. DIFAS workers almost always come in as fact witnesses. I spoke to the little girl at the school, and she told me X. Or when I went to the house There was a bruise under her armpit. She had a scratch under her left eye. That's not an expert. That's a fact witness. Even when a physician comes in and testifies that the child had a scratch under her eye, that's a fact witness. He may be a doctor, but it's a fact. He's talking about a fact that he saw on this kid. However, if he says, and in my opinion, that came from a fingernail, now we get into expert testimony. Okay? So, the other kind of expert is the opinion expert. And here are some common examples. They happen in child abuse prosecutions all the time. You have a woman who makes a statement that her daughter's injury was because she fell from a changing table. It's an observed injury. I saw my daughter, I had her on a changing table. She's 4.5 months old, and she fell from the changing table to the floor. That's what caused the injury. Well, Dr. Cronin at St. Joe's evaluates the child, he reads the film, he listens to the mother's history, he examines the child, and he concludes that it's a spiral fracture. His diagnosis is a spiral fracture of the right femur or thigh bone of the 4.5-month-old child. Now, a spiral fracture can only happen in a certain peculiar way. I think we may have talked about it in this class, but if we didn't, it's tremendous torque or force going in opposite directions generally. Now, it can happen if you fell out of a crib or fell in the yard. I think we talked about that. There are ways that children that are ambulatory, that are moving, that can walk. Babies that are not ambulatory don't get spiral fractures, okay? Not usually. Now, if they fell out of something in a peculiar way, it's possible, but you need that kind of peculiar history. With a non-ambulatory child, it's almost always child abuse. Well, this lady says, child fell from I seen it, I ran her to the hospital. Dr. David Cronin would come in and say, in my opinion, the injury is inconsistent with the mother's history. Now, what is he saying? She's a liar. That's a fancy way of saying it. And in my opinion, this is not accidental injury, which means she's an abuser. In my opinion, the diagnosis is, he wouldn't have to say that, my diagnosis is a spiral fractured mid-shaft right femur 4.5-month-old child. He's given testimony as an expert about this kid, in this case, not like all the others I talked about who come in and lecture and leave. Oh, the leave is about this, thank you, I'll go. I don't know nothing about the case. Not only do I know about this case, I talked to the witnesses, I evaluated the child, I looked at the radiological films, I consulted with the radiologist, and my opinion is non-accidental injury. The mother's story is inconsistent with my findings. That Dr. Cronin there is an opinion expert rather than a lecture expert, an opinion expert. Dr. Julie DeBellis may come in from the Children's House, or Dr. Linda Shaw from St. Peter's down in New Brunswick. They may come in and testify in a sexual abuse case and say, in my opinion, there is trauma to the genitalia that's consistent with some sort of penetration. That's the way they would express it in court. They looked at this kid's genitalia. They have an opinion about this kid's genitalia. So they're giving an opinion about the source of a traumatic injury to the child's genitalia, or in the case of a female child, the vagina, or the labia. And they're testifying about this injury. That would be an opinion witness. Okay? So you got lay and expert, and among the experts, you got two kinds of experts, right? Very good. Any questions about that? The kinds of testimony you might hear in child abuse cases: battered child syndrome. An expert could come in and testify about battered child syndrome. Battered child syndrome, generally speaking, is unexplained injury to a child in various stages of healing occurring over a course of time. So if a caregiver has a 11-month-old, and at 2 months they had a fractured toe, and at 4 months they had a fractured rib, and at 6 months there was a hematoma under the eye or a black eye, and if at 11 months the child had a full radiological scan and there were other injuries, bone injuries, in various stages of healing, one older than the other and younger than the next, we call that battered child syndrome. It's a diagnosis. And almost always it's the caregiver who's on the wrong side of that prosecution. Now, remember we talked about the case that broke during the middle of the semester? Karen Stewart. It was a baby homicide. Well, I went to meet with the medical examiner in Newark, and they performed an autopsy on the child. And if you remember, the baby died and we didn't have any brain injury, was the first report. The mother finally agreed that she threw the child down and then slapped him or whatever and then threw him down again. But there really were very few external injuries, and they couldn't find any brain injury or spinal injury. The baby died. The jury's still out on that, but when they did do the autopsy, fractured rib, fresh, probably from that night. Remember I said shake and toss, or swing it, or just toss? Fractured rib, and to see it, you get to see the injuries. It's sad, but it's what we do. Most of the time, because it's a homicide case, I get to see the injury real, the bone itself. The body is open, and you see the rib, and it's snapped. And there's the blood around the snapping. So the blood goes into the bones and around the bone. You could see fresh blood on the edges of the rib. So it was obvious that the bone, the rib was broken not too long ago, probably during that. A spiral fracture, in fact, I'm looking forward to getting the pictures because I talk about spiral fractures all the time. And here's a beautiful picture of a spiral, I should say that. Here's a picture of a spiral fracture. Sad. There's a picture of a spiral fracture. But again, most of ours that we've used in trainings before have been ones that we look at through radiology, right, through an x-ray. This is, we get to see the bone and the fracture. And you can see how it's in different directions. It looks like you would think it would look like, and you're actually looking at the bone. So, at the end of the day, this has the potential to be a battered child syndrome case as well. Because the more we look, the more injuries we found, and they were in different stages of healing, which suggests frequent battering, which would be battered child syndrome. We don't have that diagnosis. And I'm not that sure about how frequent it was. He didn't give me a report. We simply looked at him and we took notes. In the end, maybe most of the injuries are fresh and related to that one incident and not a series of incidents. But if you do have evidence of a series of incidents, an expert witness, a doctor, can give an opinion about this child. I'm not talking about Karen Stewart, but about the generic, this child, rather than a lecture witness, called battered child syndrome. That's one way someone can be an expert in the justice system with children. Shaken baby syndrome, an expert would come in and testify about the shaken baby syndrome. What the elements are, how it happens. An expert could come in, and we just talked about a spiral fracture of the femur on a 4.5-month-old. I gave you as a hypothetical. An expert could come in and talk about the possible causes of a fractured clavicle. That's another bone too. This bone here, the clavicle, that's up near your throat. Non-ambulatory children, you don't break this bone. It's one of the hardest bones to break. People don't get this bone broken. Motor vehicle accidents, yeah. Okay? You're a baseball or hockey player, someone blasts you with a stick there, you might break your clavicle. But it's very hard to break your clavicle among normal, everyday people walking around town. It's very difficult. So when you have a little baby with a broken clavicle, you're bringing in your doctor. They're going to give an expert testimony about how it's likely to be non-accidental. Now, whenever witnesses are on the witness stand, the way that attorneys attempt to undermine their believability or to make them less persuasive or effective is through cross-examination. And they call that impeachment. Think of a peach, delicious summer peach. Impeachment, impeachment, okay? Impeachment. And impeachment is simply a word that means or refers to the process of attacking a witness's credibility or believability in a courtroom. Now, how do we do that? How do lawyers impeach witnesses' credibility? Well, if the witness gave inconsistent versions on different occasions, or even the same occasion, if a witness gave different versions of the facts, they're going to be cross-examined on their inconsistent statements. We call that impeachment through prior inconsistent statements. Impeachment, through prior inconsistent statements. Now, an example of an inconsistent statement is, child protection worker writes a narrative on NJ Spirit describing what the mother said when she spoke to her at the school. CPS worker, DCP&P worker goes to the school. She meets the mother at the school. There's an issue surrounding whether this child was abused or not. The mother makes some statements to the DCP&P worker. The worker writes it in NJ Spirit. There's a DIPUS record generated. Since that subject will become an issue in the case, that record is no longer confidential. It becomes part of the case. So that record the lawyers have, the NJ Spirit document. The DIPUS worker then testifies at the grand jury because the prosecutor wanted the worker to testify at the grand jury. And she talks about when she ran into the mother at the school and the statements that the mother made. Okay? Let's say it was a daycare center or preschool, and the mother made statements about the baby being on the changing table, the 4.5-month-old one. And the worker testifies about what the mother told her at the preschool, the daycare. Then the worker comes to court and tells an account of that same day. If it's different from what she said at the grand jury, and or what she said in her NJ Spirit report, the lawyer's going to cross-examine her with that. Now wait a minute here. Today you're telling us that the mother was hostile to you, is that right? Well, that's what I said earlier. That's what I'm getting at, man. Earlier in this very courtroom in front of this jury, you said that my client was hostile, right? Yes. And that's a negative characterization, isn't that right? Would you agree that hostile is a negative thing to call somebody? I don't know. I found her to be hostile. Or would you agree that it's negative to be hostile? I guess. Now you testified before the grand jury in this case because the prosecutor asked you to. Yeah. And that happened right over here on Market Street in Patterson. You remember going there on April 5th, 2010? Yeah, I remember. Now, you testified about what my client said there. Is that right? Yes. You never called her hostile then, did you? It was a couple of years ago. I don't remember how I said what happened that day. Well, you're in luck because they write everything down there. I'm going to show you something we've already marked. D5. Okay. It's called D5, and it's a transcript of your testimony. And I put a big circle around the part that describes your encounter with my client that day. I'm going to give it to you, and there's a bunch of mumbo jumbo as a judge. We ask permission, but we're going to get it in front of the witness. Take a look at it. Don't say anything. Just read it to yourself, silently. And I want to ask you some questions. She reads it. Okay. So have you had enough time to read it? That you have? Very good. I'll take that back now. You never described my client as hostile before the grand jurors of Passaic County, isn't that correct? No. And you realize that because I just showed you a transcript of what you said, and you devoted at least 2 paragraphs to the encounter with my client that day, isn't that right? Yeah, I guess it was about 2 paragraphs. You never mentioned that she was hostile, did you? Well, she began... Judge, please admonish the witness and tell them to answer the question. Man, you have to answer the question. Let me say it differently because maybe you don't understand. Not once did you describe my client as hostile before the grand jurors of Passaic County. Isn't that true? Yes, you're correct. Okay. You wrote a report in this case, didn't you? Yes. And that's this N.J. Spear, whatever, blah, blah, blah. Take a look at that. Read it to yourself. I'll take it back now. You didn't call my client in the N.J. Spear report hostile, did you? No, but I did say about her, you want to tell us something, don't you? Go ahead, what did you say about her? That's not what I asked you, but go ahead. Well, I said she was impatient. Oh, impatient. So let's get this straight. You didn't describe her as hostile, isn't that correct? No, I didn't. You described her as impatient, is that right? Yes. Now, this NJ Spirit thing, that's the computer system that you go back to the office and you write down what happened that day. Don't you type it in here? Is that what you did here? Something like that, sir. Yeah. Well, when you type down what happened at the school that day about my client, how soon after the events that you experienced, how soon after running into my client at the school did you do that? About 4 or 5 hours later? You would agree that hostile and impatient are 2 different things, would you? They're different. Well, they're very different, aren't they? I don't know, very different. That's for other people to say. Impatient and hostile are different, yes. Well, would you agree that a hostile is far more negative than someone who's impatient, right? I wouldn't know. Well, if you're at the doctor's office, you can be impatient. But if you're hostile, they may call the cops. Would you agree with that? Judge, I object. This is counselor. Stop it. Okay, sorry, Judge. Sorry. Would you agree with me that your memory of what happened was a lot better on March 5th, 2010, when these events happened, than it is today in this courtroom? Would you agree with that? That your memory's better at the time it happened? I would. Yet today, my client is hostile. Well, that's the word I use. Well, was she hostile or not? You're in bad shape now, right? Or arguably bad shape. Because it looks like this is added to the equation later on. For whatever reasons. You want to get the guy, you want to please the prosecutor, you want to make her look bad, whatever it is. For some reason, you changed. That's a prior inconsistent statement. Okay, a little dramatization of a prior inconsistent statement. But I took her as a defense lawyer to a very bad place. And and they're very good at this. So was she hostile or not? No, you just BS the jury about an hour ago. Yes, you're completely inconsistent with what you've said for the past 2 years. you're in a bad place. And you gotta fall on your sword and say, you know what, I might have overstated here in court today. She was tapping her finger, I'm gonna come, hopefully the DAG comes and say, well, tell us about it. You know, she was tapping her fingers down, her brow was furrowed, remember I told you, what makes you say that? What are the behaviors? So you're gonna need to get yourself out of that situation. And the prosecutor, the DAG, is gonna have to help you. The point is, that's an example of prior inconsistent statement. Does that make sense? Okay. That's one of the most common ways that lawyers impeach the credibility of witnesses, through prior inconsistent statements. Of course, the other ways that they do this is to show bias in some way. Bias. If that same DIFUS worker has an ethical claim against her by my client, I'm the defense lawyer, and isn't it true that my client, you've been her caseworker for the past 5 years, is that right? Yeah, I've been with Janine for the past 5 years. Describe your relationship with Janine. Janine tries really hard, and I've attempted to get her on a straight and narrow, but things got a little, tough the past year or so. Well, my client Janine filed a complaint on an ethical violation against you last year. Isn't that true? That's right. And you've been served with that. Is that right? Yeah. Okay. Let's move on. The fact that you and the client are at odds, she's got an ethics violation against you, would be permissible cross-examination, because it would show that you have a bias. Not you have a bias. There's the potential for bias, right? Bias can arise in a million different ways, but I'm giving you an example of how the defense can show that there's a reason for you to be biased. And witnesses may not like one another for a variety of reasons, okay? One of the most famous examples of bias, cross-examination on bias, was the O.J. Simpson case. It was a detective from California named Mark Furman. And it was a lot of legal argument about whether the defense was going to be able to show that Furman used the N-word to describe, on more than one occasion, African Americans in Los Angeles during the course of his work. And the prosecution was like, what does that have to do with this case? That's his personal life, that's nothing to do with this case. Well, the defense said it has everything to do with this case. You got a privileged celebrity African American accused of killing his wife. And if the lead detective, who we're saying planted evidence on the guy, doesn't like black people, the jury ought to know that. And they won, and they got to hear it. And he was acquitted. But what was the defense strategy there? To show bias, general bias. Is another example of bias. So bias is always in play. If a witness has been convicted of a crime, you're allowed to show that the witness has been convicted of a crime. Most of the time you can't say what crime it is, but you can show that the witness has been convicted of a crime. And the theory behind that is, if a witness has violated the societal rules, then it's not a big deal for them to lie or BS in the court. Now that doesn't mean that's true, that everybody who's got a prior record is a liar and not to be believed, but it's just one thing the jury ought to know about. If they have a criminal conviction for a felony, jurors get to hear that, and they can size it out and go, you know what, when I weigh... Now usually the things that jurors are influenced the most by are convictions for truthfulness crimes, like fraud, deception, theft by deception, ID theft. That's the kind of witness that you don't want to walk in a court with. But a guy who's got a burglary or a fight or an assault or something, that's admissible. The jury gets to hear it. That's not that big a deal, though. It's not going to have that much of an impact. But it's admissible because it has potential for some impact. So criminal convictions, okay, are admissible in New Jersey and in most states. Some states it has to be a crime of veracity. Veracity means truthfulness, like I said earlier. In New Jersey, it can be any felony. Obviously, a defect in capacity may be admissible. Your ability to perceive events, to think, to see, to hear, to smell. Isn't it true you wear glasses? Were you wearing glasses that night? Well, I left them home. Were they reading glasses? Are you nearsighted, farsighted? If you're an eyewitness to something, then it is common for you to be cross-examined on your ability to see. Right? It's always fair. Perspective. You may have the best vision in the world. But if there was a couple of pillars in your way, or it was dark out, and the trees had full foliage, the leaves were all out, and you were 1,000 yards away, right? Well, that may undermine your believability if you say you saw him, you know, punch her in the shoulder or jab a knife into her thigh. In that Blade Runner prosecution in South Africa, there's an issue about a woman or a witness who claims she heard or he heard a knockdown argument at or about the time she was shot. He shot, this is indisputed, he shot his model paramour in the bathroom and she died. He says he thought she was an intruder. We talked about this. There's a million unusual aspects to how that can ever be. But he's out on bail, going to clubs and hanging out. She's dead. But it was shown through cross-examination in the preliminary hearing on bail that the witness who heard the commotion, like lived on the other side of the condo or something. Again, I'm paraphrasing, I have no idea, but I do remember that the ability to hear and the distance of that person's condo or location to where the apartment of the fight occurred was significant, according to the defense cross-examination. So it seemed like, oh, I had a great witness who heard everything, really was pretty far away. According to the defense, that may have been misrepresented because the cop who represented the government on that day was fired because he has a homicide charge against him. Certainly defects in capacity, whether you can see, whether you can hear, they all make sense, right? You're going to get cross-examined on those things. Inadequate opportunity to observe events. Remember that child sexual abuse accommodation syndrome is not what? Not a diagnosis. Okay, that's kind of a nutshell, experts and cross-examination and impeachment of witnesses. Do you have any questions about anything in the course, or certainly anything we talked about today? I'd be happy to answer them. You know, I have that discussion board for the final exam. Use it if you want. I subscribe to it, so I'll get them on my iPod, on my iPhone. I'll get them on my computer. I try to respond as soon as I can. Let me double check, make sure I am subscribed to it. I thought I subscribed to it. Let's double check. If you're going to use it between now and the exam, that's one way we can review together. You should. There ain't going to be a lot of action in it, but if there is, then it's a good thing, right? You should subscribe to it, and here's how you subscribe to it. I'm going to discussion forums. We'll scroll down to the last one. Final examination review. I'll click on it, and I am not subscribed to it. Right here, subscribe. And that should give me subscription. I'm subscribed to the forum. So now, anytime anyone posts to that, I'll get an email. And I have the app. I have the Blackboard app on my iPhone too. The Blackboard app works really good on iOS, by the way. You know, most of the time it's clunky and hard to look, but this one works, it's pretty good. I mean, it can't do everything, but the discussion forums pop up just like a text. Little bubble, green bubble, and a white bubble. It's pretty good. So that's, I'll see it in there too. The Blackboard mobile learning. What are we, here's us. And like I said, if you you should be in a good position to take the exam if you listen to the I went over a large part of the what's going to be on your final exam. Last week and this week. Here's what this is my iPhone. Here's what the Blackboard app looks like in the discussion forums. They got it for Android too. It's kind of easy to use on the go, especially if, in the beginning, if you're taking a course next semester. In the beginning, it didn't work that good, but it works really good. It's got kind of works better than the web one. Why does it keep rolling up? I guess when I move it. Okay, well then, you got another course after me, right?
Yeah.
Get some study time in. We're going to get out of here.